happens when the person holding everything together, the caregiver, the planner, the healthy spouse, dies first? It's not something families want to talk about, but it does happen. And when it does, the effects can be devastating if you don't have a plan in place. Hi, I'm Barbara McGinnis, a partner and certified elder law attorney with Johnson McGinnis. We help families navigate the legal, financial, and emotional complexities of aging, and sometimes that means planning for the unthinkable. Today we're going to talk about one of the most challenging scenarios we see far too often. What if the caregiver spouse dies first? Well, let me tell you about a family we recently worked with. We met a family facing a tragic and complicated situation. In December of last year, Don passed away. While he was in his early 80s, he appeared healthy and in fact was a caregiver for his wife Susan, who was in mid-stages of dementia. She could still perform most of her activities of daily living, but certainly required supervision, prompting, and cues to do everything. She could not live alone. Their only child lived out of state and rushed home not only to bury his dad, but to care for his mom. They did not have an estate plan. No documents. Donnie contacted us to see where to begin. Well, we helped him with the probate process and guided him through that. But because Mom's dementia was so advanced, she was not able to name him as her power of attorney, and he had to file a conservatorship for her to get legal authority. Well, all of this was more chaotic, expensive, and time-consuming than it really should have been. If Don and Susan had put together an estate plan when she first started having problems with cognition and communicated that plan to Donnie, well, these life changes could have been handled much more smoothly. When a well spouse or caregiver passes away, the surviving spouse, especially one who's ill or vulnerable, is left in a very fragile position. Let's talk about how assets are treated after the death of someone. If your home or accounts are owned jointly, especially as tenants by the entirety, those assets will automatically pass to you, the survivor, outside of probate. This can offer some much-needed stability in a difficult time. Some assets will pass by beneficiary designation, like qualified funds or life insurance policies. Others will pass by will, and here's a common problem. The deceased spouse never made a will. If that happens, Tennessee law actually decides how the estate is divided. If there's no children, spouse inherits it all. But if there are children, even from a prior marriage, you would wind up sharing the estate with those children. And that can lead to tension, conflict, and legal delays. Good estate planning for a couple like Don and Susan would have included a testamentary supplemental needs trust in their will. These documents would have protected assets for the benefit of the disabled spouse in the event the well spouse died first. Listen, no one wants to think about losing their spouse, especially when that person has been their rock, their caregiver, their planner. But having the proper documents in place can make the difference between chaos and clarity. If you or someone you love is in a caregiving situation now, please don't wait until something tragic forces your hand. We're here to guide you through the options, provide peace of mind, and help you protect your family, no matter what the future holds. Reach out to our team at Johnson McGinnis. Let's build a plan that's strong enough to weather anything, even the unexpected.